In 10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
Greetings, everyone. Thank you for joining Turning a Moment into a Movement. I'm glad you guys are here. Sorry for the delay, but we're here. My name is J Love, and the moment was for me when my son Gerard was wrongfully incarcerated for a crime that he didn't do. And so that birthed this movement, turning a moment into a movement. So I'm going to bring in our guest panel people. Hello, Tia.
Hello, how are you?
Hi, how are you?
I am wonderful, wonderful.
Great. Good evening, Pam. Good evening, Michelle. And hi, Larry. We're here. So let's bring in Allie. Hi.
Hi, how's it going?
Oh, it's great. Everything is going great today. We're running a little late, but it's all good. It's all good. We right on time.
We made it.
Yeah. I see Edward is in here, but I don't see him yet, so we won't bring him in yet. But thank you guys for oh, okay, here he is. Hold on. Hi.
Hey, how you guys doing? Good to see these faces and hear these voices. You all look beautiful.
Oh, everything is good. I'm so happy. Tomorrow's my birthday. So
Happy birthday.
Thank you. Please, Attorney Hugo Mack.
Look. First of all, our leader, let me apologize to you and all the other panelists here. Joe and Cameron be blowing up my celly every day. I just had to cut them off, so I apologize. So I'm back with you now.
All is well. All is well. So we're gonna start with Tia. Tia, for those, this may be their first time joining us. Introduce yourself and tell everyone what it is that you do.
Okay, my name is Reverend Tia Taylor, and sometimes I go a lot of times on Little John on Facebook, and I am a Little John, okay? However, I am a minister at Transforming Love Community, and I am active in social justice. Actually was in the first cohort for social justice for Mary Grove College, and got to give them their credit. And I am right now, along with J Love, I am definitely a part of turning this movement, the moment, into a movement.
Yeah.
I'm also working with Commissioner Bishop Jefferson out in Flint, helping to get reparations for Flint residents. And I also, I call myself the supporter for all things that mean that are important to me. So look, I write, I sing, I do whatever God calls me to do to bring awareness and to encourage people to trust God, depend on God, and to know that we can make a difference and that our faith is going to bring us to where we want to be.
Yes, ma'am.
Yes.
Thank you. Allie, introduce yourself. For those that it might be their first time joining us, so introduce yourself.
Yes, my name is Alexandria, go by Allie. I'm with Michigan Liberation as well as Michigan Liberation Oakland County team, and as well as Accountability for Dearborn. I'm an all-around activist, so I go where help is needed, where my primary focus areas are Oakland County, so Southfield, and then Dearborn. I fight this fight because what's happening to Black people is just wrong. There's a cycle of hate that continues and it has to stop. And I also fight this fight because I truly believe a woman's body is not a group discussion, and it commonly is. And what's happening in the world is damaging our mental health and well-being, and that just needs to stop. Glad to be here.
I'm glad that you're here. Hi, greetings, Edward. Introduce yourself and tell the viewers what it is that you do.
Okay, thank you for allowing me once again to be on your show. My name is Edward Sanders. I go by the name of Baraka. I'm a returning, what they are referring to as a returning citizen. I'm still in debate of whether or not I accept that term. But for right now, until I get through examining it, I'll take and deal with it. I spent 43 years in Michigan prison. I went to prison at the age of 17, came home just prior to my 60th birthday in July 2017, was prison in 1975. I recently graduated from the University of Michigan School of Social Work with a master's. I'm presently employed at the University of Michigan School of Information, working with projects addressing returning citizens. I'm socially active with Ali organization, Michigan Liberation, and others. And I'm continuously expressing concerns for those who I have shared a common experience with for the last 40 plus years. My voice is still in that space and raising above and beyond it to speak for those who are not able to take it and be heard. They are very capable of speaking for themselves. And thank you very much.
Thank you. And Attorney Hugo Mack. Hi, tell the viewers who you are and what you do.
Well, first of all, once again, so grateful to be here with everybody. My name is Hugo Mack, licensed practice in the state of Michigan. Unlike some other people who graduate from law school, I did not graduate summa cum laude, magna cum laude, or cum laude. I graduated thank you laude. And so for me, it's one of those situations where I'm very grateful and humble for what God has done for me, because I certainly could not have done it myself, you see. Yeah. So I'm thankful for that. I understand, and there's a passion in my heart for the wrongfully convicted. Having been a wrongfully convicted person myself, serving time within the Michigan Department of Corrections, paying a debt I did not owe, but through the grace of God, able to come back out and regain my law license, something that never happened before in the history of the state of Michigan. So I met many, many people in my sojourn through the Department of Corrections that should not have been there. And it's not just a matter of being wrongfully convicted, it's a matter of being overly convicted, okay? You see, that is a very, very serious problem we have, which is almost as nefarious as being wrongfully convicted. Because when you're overly convicted, you can get basketball score years, and quite easily die within the penitentiary. And that turns into a death sentence. So I'm very, very keen and sensitive to the needs of people that have been done wrong, people that are deemed returning citizen. I say I have had a criminal justice involvement that come out and face hardship and prejudice. I'm very, very keen to women that have been victims of domestic violence, abuse of all manner, defended over 800 of them, where there were none of these organizations de jour, who say they stand for this. Next week, they'll be fighting for the whales. So what I'm saying is my commitment is a long-term one to justice, not only civil rights, but human rights, because it's a human dignity issue that confronts sexism, racism, classism, you see. And so I'm dedicated my career to fighting in my venue. So that's what I'm about. And as long as the Lord give me breath, that's what I'm keep on doing.
Thank you. I'm so glad you guys are here. And we all on the same team. It's so wonderful. Let's get started. Today we're going to talk about inadequate defense. And I'm going to start off with this video. And then I'm going to come to you, Attorney Hugo Mack.
The defense lawyer doesn't do his or her job, justice suffers. And the defendant may even be wrongfully convicted, in which case the real perpetrator remains undetected. Earl Washington Jr.'s case is just one example of an exoneree wrongly convicted based on inadequate defense lawyering. He was convicted in Virginia after a trial lasting less than 5 hours. His lawyer had never handled a death penalty case before, did not challenge the confession or hire an expert to develop why Washington confessed due to mental retardation and called only 2 witnesses in Mr. Washington's defense. Washington would come within 9 days of execution and would spend 22 years in prison before DNA exonerated him. A review of convictions overturned by DNA testing reveals examples of incompetent and overburdened defense attorneys, including those who are sleeping or drunk at the trial level and on appeal. In general, the defense case brought on behalf of these innocent people was short and weak. Because post-conviction DNA testing can only be used in a very small percentage of all criminal cases, the trials of these innocent people represent only the tip of the inadequate defense iceberg.
Wow. So, Attorney Hugo Mack, can you explain to us what is an inadequate defense or ineffective counsel?
Okay, first of all, perhaps it was my system, but I really could not hear what that gentleman was saying, but I caught bits and pieces of it, enough to know some of the highlights. And I agree with what the gentleman was saying in terms of counsel not being prepared. First of all, let me tell you, as a person who's been privileged to be in thousands of court hearings, inadequate defense is not as rare as you might think it is. The problem is, with systemic racism, there needs to be a constant justification of the system. And part of the problem that we have is the courts, and I've been very critical of the judiciary, the elected judiciary, not only on the county level, but on the Court of Appeals level, on the Michigan Supreme Court level, when everybody who is running for judge is actually running for sheriff. There's a big difference between a judge and a sheriff, okay? A sheriff, you kind of expect to be suspicious and supposedly ferret out crime. You don't expect that in a judge, all right? So part of the problem when we talk about inadequate defense, the past that's built into the cake is with the judiciary, because the judiciary refuses, through what's known as harmless error, to hold several attorneys, defense attorneys, prosecutors, and police responsible for doing their job. So in other words, if you've got a big excuse, a big door, that any kind of inadequate defense can just be explained as, oh, that's trial strategy or what have you, then you perpetuate that system where attorneys, and I was a public defender for 12 years with a tremendous caseload, some of them just get too damn tired. They come in with zeal, with passion, they want to be justice fighters. But I'm telling you, when you sit at your desk and you've got a stack of cases that are like 3 feet high, it gets wearing, and which is not an excuse, but it is a reality. So what happens is, a lot of times, and you've got to remember, criminal defense lawyers are not on the high end of the pay scale. Okay, people that get appointed. You've got some people that are extremely wealthy that can quote unquote retain their own attorney, but most people, particularly black people, don't have that kind of bankroll to do that. So either they're borrowing money from Medea, putting the house up for mortgage, or they're stuck with a court-appointed lawyer. And the system is so top-heavy against court-appointed lawyers, it's hard to get an adequate defense. So part of the problem is in challenging the police report. One thing that I learned, and one thing I've tried to mentor, young defense lawyers coming in, don't assume that police report is accurate, okay? Your responsibility is to dissect and attack that police report. See, because let me just give you a little glimpse behind the curtain with the Wizard of Oz. Those police reports are sanitized before you even see them. Because what happens is, let's say the officer on the street who encounters Sister Hughes or Brother Sanders, all right, they make some form of an arrest, they write a report. Well, before you even see that report goes to their sergeant, and their sergeant tells him or her, okay, now wait a minute now, this doesn't make sense, okay? So you need to tighten this up. You need to have make it appear in far too many cases that there really was suspicion, or you were fearful for your life for example. That's why you took the conduct that you took. So part of the problem is when attorneys do not aggressively attack that police report. And, to the extent of, well, excuse me, officer, this is your police report, but I like to see the notes you made at the time, because they make notes and that's what the police report is based on. See what I'm saying? Defense attorneys rarely get to see that. So I guess without monopolizing the conversation, a lot of it comes from not having the proper information from a truthful source and not having the resources or training or capabilities to get that proper information. Because without the proper information, you come into the game and stacked before the ball is even snapped. The game is rigged already. And that police report leads to 85% of inadequate defenses because you don't have the truth in front of you.
Wow. Everything you said, the system is rigged against you because it all goes back to the police encounter and the police.
Absolutely.
I was going to say another thing too. Actually, even this week, a friend of mine was pulled over in Pontiac. His police report says that he was born in like 1980 something, and he was not. It's completely wrong. He's in his 20s. He's like 22. Yeah. So that's completely true. And also too, it depends if, private, court-appointed lawyer versus a private attorney. Your lawyer could have more cases than they can handle. And on top of that, they, more cases than you can handle. You don't have the resources or the time even to even get sleep and things like that. And if you're a newer attorney, then that's on top of all those things. So it just sets you up unfairly. And I would imagine it's overwhelming for the attorney too, to know that and then have their life in their hands.
Right.
It's like setting both parties up for failure.
Right. That's a good thing you said that, because one of my notes was shrinking funding and access to resources for public defenders and court-appointed attorneys is only making the problem worse.
That's right. That's right.
Edward?
Yes. Can you hear me on my mic?
Oh yeah, I can hear you.
Okay, great. This is a very pertinent discussion as it relates to the lack of justice in the so-called criminal justice system. Attorneys are 90% of, at the very minimum, 90% of their work is pre-trial investigation. If they're involved in a trial, 90% of their work at the very minimum is pre-trial investigation. And many attorneys are not meeting that minimum requirement. They're showing up in a courtroom and believing that they can perform in front of a court. And that's the last place that they can try to perform, because there are so many strenuous rules that are laid down that you must adhere to. Okay, you can't just say anything. You can't just ask any questions. You can't attempt to introduce just any old kind of evidence. And even if you could do it, you may do more harm than you can do good. So I emphasize once again, at the very minimum, 90%, at the very minimum, 90% of attorneys' responsibility is pre-trial investigation. Many times you'll hear the accused say, I didn't even talk to my attorney until just moments before we actually went into a courtroom. That there tell you that he or she obliterated or abrogated, or, that responsibility of adequate pre-trial investigation. You should also remember that in every courtroom, there's a minimum of 3 attorneys. One of them is for the defense, the other one is the judge, him or herself, and the other one is the prosecutor. They are all attorneys. They belong to a fraternity. And I will stress that again. And they very seldom take and judge each other adequately. They very seldom judge each other adequately. This is where The right to a public trial is important. As a member of the public, you have a right to show up in a courtroom and observe a public hearing. And as citizens, we should take that responsibility as opposed to taking and wanting to, when you're interested in a case, as opposed to waiting on the evening news to characterize the case and to sensationalize the case. It don't hurt to take your butt down there and sit down and listen to the evidence in the case. And this can be said about activists and organizations that advocate. We can take and show up in that space and we can provide a lot of good. We can say to a judge or to a court, whether it's the presiding judge or the chief judge of that court, we can say that you left that defendant, that person that was accused, you left that person to the mercy of an incompetent attorney, and you can raise your objections with the court. You can take and see a prosecutor taking and entering evidence that are not germane to the accusation in the case. And you can file grievance against that prosecutor and say that, hey, this person was on trial for A, B, or C, and the prosecutor spent most of his argument arguing about things that had nothing to do with that accusation, and the judge allowed it in, and the attorney failed to take and make adequate objections to it. And as a member of the public, you can raise your voice, okay? So in a way, I may not be necessarily saying what is ineffective assistance of counsel per se, and I'm taking and talking to the public of what you can do, because sometimes we don't realize some of the things that we can do. Like, we tend to take and glamorize the Black Panthers. We like how they looked. They you know, their outfit and everything, and the masculinity and all. But you know what? They took the time and explained these type of things to the public. These are the type of things that they meant when they talked about self-defense. It didn't just include taking and putting a gun on your shoulder, you know, the long firearm, or on your side. It also took and reminded us of our duty and responsibility to learn our rights. I know that because as a child, I grew up in their centers, whether it was on Mack Avenue or whether it was on Forest or whether it was somewhere else. I took and grew up and went to their centers, and I know what they was teaching. And these are some of the things that they taught us. They took and told us that we had a civic duty as members of the African American community and as American citizens to know our rights and to assert them. Now, nobody goes into a courtroom as accused and know his or her rights. We should know some basic rights, but that is the duty of the attorney. And again, the most important duty of attorney at the very minimum before he or she go in that courtroom is to take and do pretrial investigation. 90% of their duty would require that. And the remainder is to take and then assert it once they get in that courtroom.
Mm-hmm.
Tia, did you want to say something before we move on?
Yeah, you know what, I wanted to raise the question because, you know, I try to think about what our viewers are would want to hear answers to. So what I'm looking at when it comes to inadequate representation, when I think Attorney Mack had mentioned aggressively investigate, and what is there to force or the kind of incentive or accountability for that attorney to aggressively investigate? Because I know that many people can do something. It seems like it's after the fact, but there's nothing. It doesn't seem like there's nothing. There's anything in place, and this is what I'm finding in many of the systems as far as when it comes to systemic racism, is that there's nothing in place to prevent, on a preventative, proactive measure to prevent this type of misrepresentation. So there's nothing that holds them accountable so that they do aggressively investigate. Because from what I understand, they call it sins of omission. Mm-hmm. They omitted something. They didn't investigate something. and I don't want to call it lazy because I understand that the workload can be massive and overwhelming. However, somebody's life is at stake. And I'm wondering, is there something that we can promote or do so that something is in place to prevent this from happening?
If I just want to say, it feels like it just feels like you need eyes. You need to be a fly on the wall in every part of the system. That's what it's feeling like. Because all these conversations, whether it's the police, whether it's the attorneys, whether it's public attorneys, private prosecutors, whatever level of the system we at, I just keep feeling like we need to have people watching to hold them accountable, because it's to make it where these are seen as people. These are people. This is not just paperwork. We just not pushing paperwork, and that's what it's become. Yeah. And it just seems like the people need to hold them accountable, like have eyes on them. It's just what I'm hearing.
So before I go any further, our guest, Arthur Bean, has arrived. Before you comment on what we're talking about, can you introduce yourself and tell everyone what it is that you do?
I'm a research investigative assistant, and I write legal briefs.
Thank you. So we're talking about inadequate defense.
Yeah.
So I'll let you take it.
I think the working relationships that these attorneys develop with these prosecutors, they become complicit with the prosecution to a degree. And laziness.
You cut off.
Failure to investigate.
Okay.
I think some attorneys have their own prejudices too.
Yeah, that's true. There go that word, confirmative biases, that we've been in this whole series. It comes up in every aspect of a wrongful conviction. According to the Exoneration Registry, inadequate defenses contribute to 80.6% of the cases, while trial errors were found in 50.8% of these wrongful convictions. In 34.7% of the cases, the failures were solely investigated. So again, it comes down what you guys were saying, Attorney Hugo, Matt, and Edward, about the investigation.
Absolutely. Can I say something?
Yeah, go ahead.
Okay. Well, part of it is in terms of what the Reverend was asking about. There are different safeguards that are in place. You know, in the state of Michigan, for example, there's the Attorney Grievance Commission, all right, which is controlled by the Michigan Supreme Court. The Grievance Commission serve as prosecutors, and the Attorney Discipline Board serve as judges. So any attorney in the state of Michigan can be grieved, all right? And if that grievance is found to be substantiated, there's like censure, there's suspension, all the way to disbarment. So the public does have, and as they need to have, a means of raising attorney conduct, okay, to the point where someone could actually lose their license. You see, that's the reason we need like a national registry for police. That's the reason we need to eliminate qualified immunity. See, because in a lot of these cases, they don't have a counterpart to me in a police department. You understand what I'm saying? I mean, there's no official record kept where anybody can look and see, well, this attorney was disciplined 5 times. Well, I don't want to hire him or her. You know what I mean? There's nothing like that. So the police don't have a backstop to prevent corruption like attorneys do. And there's some attorneys who know how to skate the system. They know how to do just enough to get by. So you can say, well, I did go see the client, and we spoke for a half hour, and they know good and damn well that was not enough time to fully investigate this and deal with the trauma. Because I'm telling you from personal and professional experience, when you're talking to somebody that's behind that wall or talking to you behind that plexiglass, that is a singularly terrifying experience. And I don't care how tough somebody want to be out in the streets. When you get behind that wall and then people telling you what to do and how to do it, and if you don't do it, they got something for you because it's more of them than it is of you, all right? and they've got the state police, everybody backing them up. That is a terrifying thing. So part of the problem, and I don't mean to get long-winded here, but part of the problem is people don't understand there are ways to hold attorneys accountable, and people also don't understand, like Mr. Bean said, is that there's oftentimes a relationship that's built up. I mean, in Washtenaw County, for example, they've got attorneys that are assigned prosecutors to a courtroom. Now, some of you may say, well, okay, I mean, isn't that nice and efficient? Yes and no, because that judge gets familiar with that prosecutor. They do business with each other every single day. And familiarity can sometimes breed a false sense of trust and integrity, okay? When every case ought to be looked at as a judge, I don't care who the prosecutor is. I'm here to uphold the law. I don't care if Mr. Jones or Miss Smith and I, we get along good and we laugh and joke, and we kick it, in bench conferences, beforehand, or we see each other at a bar function, sit together and talk. The judge shouldn't be influenced by that. But a lot of that familiarity comes in. That's why you need defense attorneys that are aggressive and will challenge the judge if necessary, okay, in these matters, and make a record. That's another thing I'm gonna say. A lot of defense attorneys are scared to make a record because they don't want to piss the judge off, okay? And what I'm saying is that you've got to make a record because that's the only way any appellate court is gonna look at it. Because if you don't raise that issue in trial when you have an opportunity to, most times you've raised that issue, okay? So attorneys got to step to the plate and be fearless in making a record.
Allie, could you, I put your comment up. You speak on that.
Yes. What that link is, it'll take you to the current, the current bill, HR 1280, the Justice and Policing Act, George Floyd Act. The House just passed it and it's now in the Senate. And if the Senate were to pass that, then that would mean qualified immunity it would mandate data recording in terms of the police, prosecutors as well. It will also require, I believe, body cam footage, multiple things. So and data collection, like in transparency, all that would be mandatory. So that link will take you to a page and you can plug in your zip code and it'll link you to who your senators are, where the phone numbers are, a pre-populated message. And you can send that and it'll go off to the senators and let them know that it's time to approve this. So it'll allow you to push that bill. So please click that link if you can. It's definitely time for qualified immunity to end.
Yes. I have a statement from Beulah Walker, and she said, I have filed many grievances against attorneys here in Michigan to the Attorney Grievance Commission. They refuse to summons them. At the time we have Bill Schuette as the Attorney General. Attorney Hugo Mack.
Well, I mean, it is true that most grievances that are filed when they do an investigation, most of them are not substantiated. All right, I mean that is true, and part of that is that the way the law is structured. I can just speak in terms of criminal defense work. There is, like I said, once again, there's this huge door that everybody should remember. Okay, harmless error. Okay, trial strategy. So these are like two big horse barn doors, all right, that literally any kind of injustice that goes on in a trial can be excused through one of those venues. So part of the problem or reality with the Grievance Commission is they will let you know that it is not our job to go back and deal with what you think is an issue of trial strategy, where your attorney should have called somebody as a witness and they didn't, or they should have cross-examined this way and they didn't. They'll let you know that is something you need to take up with the court system. And the court system's response is that's trial strategy or it's harmless error, you know? Mm-hmm. So that's the catch-22 that most citizens find themselves in.
I have a question, Attorney Hugo Matt. How, I guess for people that want to overturn their case who feel that they had inadequate defense, is there an average amount of time it takes to fight those type of cases? Because I'm thinking of a case, and there's a woman, and she started fighting this case in 2013. Her name is Chandra Bozelko, and she started fighting this case in 2013, and she's trying to overturn it because it's, you know, she was convicted on theft-related crimes in Connecticut, and she's been fighting that since 2013, and she has another trial set for 2021 sometime, but it's been since then. So my question is just, is there an average, or is it just whatever it takes?
Well, yeah, I mean, you know, excellent question. You know, there's a seminal U.S. Supreme Court decision called Strickland versus Washington. All right. And what happens is that sets out the standards that a person has got to assert and prove in terms of ineffective assistance of counsel. Okay. So, I mean, an inadequate defense can include ineffective assistance of counsel. Okay. So those two can be related, not necessarily related, but they can be related. I can just tell you from the court system in the state of Michigan, everybody is, this lady's in Connecticut, but let's say if she was in Michigan and was convicted in, let's say, Wayne County Circuit Court, she has an automatic right to an appeal to the Michigan Supreme Court within time limits, all right? So the opportunity or the responsibility is on her to raise that through the appellate system and try to get relief. The problem is, once again, it's like a circle. It's like a ring. It has no beginning and it has no end. The problem is many judges that are on the Court of Appeals, these are former prosecutors, all right, who got elected there. If you notice, a good way to get in a position to run for higher office is to be a former prosecutor. Okay, so Bill Schuette running for governor, well, he was the chief law enforcement officer of the state. It's called the Attorney General. Okay, so that is a good platform, and we bring some biases with us. I mean, be very honest. I mean, and so I think some of that implicit bias comes with us, and with some of these people that are judges, they've really got to get up every morning, putting that old suit or that old dress away. You know, putting that away, never to be revisited again. So, in terms of the time frames, you know, Bill Clinton and them, you know, with the omnibus crime bills, you know, severely limited the time frames for people to file habeas corpus actions, for example. Okay, so it all depends on your jurisdiction, but if you don't meet those time frames, you default on that issue unless there's some reason. All right, some newly discovered evidence or something you couldn't have brought up earlier. Sometimes in Michigan it's called a 6500 motion. You know, where you go back to the trial court and say, hey, well, look, this was not brought up in the trial or in the appeal, and this is the reason why. Once again, though, very difficult to get success in those venues. Very difficult.
I want to throw out, due to case overload, well-meaning defense lawyers are subject to meet them and plead them routine. It's a large reason why 90 to 95% of their clients plead guilty. And do you see where it says estimate time each attorney has to spend on a case? I was just like, okay, New Orleans, 7 minutes, Detroit, 32 minutes, Atlanta, almost an hour. I know I could just go back to my son. I think he saw his first lawyer maybe twice. And when I met her, she was coming in the courtroom with a stack this high of files in her hands. So how do you, get someone who really is going to look out for you when they have a stack this high for today for cases?
And if she dropped them, her whole week would be mixed up.
Right.
If you consider the most transformative attorneys today, which would include Barry Shack and Brian Stevenson, these two people, these two defense attorneys or appellate attorneys, are transformative because they are humble enough to make use of other disciplines. Many attorneys are very arrogant. They're very arrogant. They have a great deal of knowledge, and they fail to humble themselves with that knowledge or that information that they have. And they become very haughty, and they are not considerate of others' opinions, including their clients. And they don't respect other professionals. And as a result, they don't get a chance to use other professionals' tools and knowledge in the courtroom where it's really needed. You need other players in the courtroom. The prosecutors do it all the time. But if a client of attorney does it, most often they feel that the money that the client is trying to spend on that other source should go in their pocket. So it doesn't only include a haughtiness, it also includes greed. When you tell your attorney that you want to take and acquire an expert witness, or you want to acquire some type of ballistic examiner or whoever, somehow they think that that money should go in their pocket. They can go in the courtroom and just fight it out. And many times you can't do the gladiator thing. You can't do the gladiator thing without the other thing, and that is taking and having other voices, other branches of knowledge, etc. Look at O.J. Simpson case. We all take and give credit to those 5 beautiful attorneys or more that came in the courtroom. We even glamorized them. We took and said that they were what they gave them a hell of a name, but in the dream team or whatever it was. But the really dreamer on the team was a woman that was never seen in the courtroom. She was not only an attorney, but a psychiatrist that took and acted as a jury consultant for the case. That case was won before it was even started because she was able to take and look at the theory of the prosecutor's case and the theory that the defendants want to put forth. And she took and advised them how to proceed with that case. Okay, her consultant in that case took and won that case. All attorneys had to do was play the script once she had took and done her part. But many attorneys are intimidated. They are intimidated, or they're too damn arrogant and too greedy to take and allow elbow room into the courtroom. And many times you will find the appellate courts, when they take and find attorney incompetent, they said attorney failed to take and seek expert opinion or usage in the case.
Oh, wow. Tia.
I was sitting here saying, wow, just like that, just like then I had my mic on mute because it's amazing how when you feel that you should have equal access and equal treatment, people still bring their biases with them.
Mm-hmm.
And I unless there's a penalty, unless there's a way for them to be have accountability, that they continue to do it. They're going to. And unless we put people in the proper place, where we have people who advocate for all people, including African Americans. The sad thing, though, and this is what I want to make sure that we are aware of, is that a lot of people who are very discriminative don't even realize that they are. Many are, just grow up like that and they don't know. And when they believe that they're doing right, they still don't know. And I believe that there needs to be training on diversity, and not just diversity where you can put up with somebody. No, where you embrace people who are different from yourself.
Right. Sherry People said, who's my cousin? Hey, Sherry. So you're saying to bring ineffective assistance of counsel, you have to hire another attorney to prove he was something on his duty, vicious cycle. I believe not until it's affect their money will they fight harder to exhaust all areas of the fight and back to accountability. I read also while I was going through this that it can happen with a paid attorney. You can have an adequate defense and pay somebody to represent you. So it's not always. It happens more often on the public defender end, but it also can happen if you pay someone.
J-Love, in 75, I retained a well-known attorney here in the city of Detroit, a well-known criminal defense attorney. My grandmother took and retained him at my direction. And this man, unbeknown to us, he was getting so many retainers that the chief judge had ordered him not to take any more retainers. They say you can't take, and I'm talking about Charles Campbell, all right? They say you can't take and represent everybody. You have to tell some of your clients or potential clients no, that you have too many cases. Campbell didn't do that. He took my people's money, and then when it came time to show up, he didn't even show up on the first day that the case was scheduled to go to trial. Just so happened it had been postponed, but he shows up on the day of trial and asks for a continuous because he wasn't ready, because just like what the court had told him not to do, he was doing. He was still accepting retainers. This man used to take and intentionally act up in front of a court so the judge can hold him in contempt of court and throw him in the bullpen. But he had a game plan. He had his pocket full of his cards. When he go to the bullpen, everybody is saying, there go Campbell. He out there fighting for his clients, and the judge throwed him in the jail with us. While he back there, he passed out all his cards. The judge let him back out. He got 1,000 other damn clients throughout the county jail again. This was his ploy. Okay, so the judge say no. He shows up on the day of trial and asks for a continuous because he wasn't ready. The judge say no. The court rule is that you got to be ready, able, and willing to proceed. You cannot take and show up on the day. He showed up on the day of the trial and actually tried to enter his appearance. Okay, I've been in the county jail for 6 months. My attorney hadn't even filed his damn appearance because he was trying to hide his involvement in the case because he was under order by the court not to take any more retainers. Okay, so guess what? Guess who I was forced to go to trial with? A state-appointed attorney.
Wow.
Who was only trying to force me to plead guilty. That's the type of trial I had as a 17-year-old in the Detroit Recorder's Court. But guess what? All my judges were African Americans. They could have stood up and say, no, that's not going to go down. In fact, one judge took the file and threw it across the table, but I wind up in another judge's courtroom.
That's another week we're gonna have to talk about. I was reading a book, locking up our own. That's a whole nother conversation for a whole nother week. But That's big, what you're talking about, Edward. Attorney Hugo Matt, the Sixth Amendment guarantees us criminal defendants a right to counsel. And so what Edward was talking about with this guy who's just going around, you know, getting retainers, it seemed like that would be something that somebody could do about that. Oh, I can't hear you. Hold on.
I'm sorry. Well, I tell you what, excuse me for being from the streets, but listening to what I heard Edward say about that man, I can just say pimping ain't easy. And so what I'm saying is, what's happening is that man was legal pimping and making it look easy, but really pimping ain't that easy. You know, so what I'm saying is that what's so unfortunate is that sort of thing happens. I may not have seen it happen to the level that Edward's talking about, but I clearly see it happening on a more nuanced level, you know, where attorneys get a reputation. Well, yeah, you know, maybe one or two cases go their way and then people become desperate. But, you know, it's not the size of the, how do they say, it's not the size of the dog in the fight, but the fight in the dog. So I'm saying to people, don't just throw your money away on quote unquote a big name. You know, I mean, that's not it. You got to do your diligence. But unfortunately, with so many people, particularly people of color, we don't have a bunch of money unless, you know, Medea or Big Mama, you know, somebody willing to put up the house, you know, or go into their savings or something like that. We don't have that. And I think everybody who said it is right. Just because you got a private attorney, that's no guarantee of fairness. Please don't fool yourself into thinking that, you know. So it's going to come back to the people that take that oath. I agree with what Edward said. It is a fraternity, you know, but some of us are damn near blackballed from that fraternity. And so what I'm saying is that you need people that are going to be willing to stand up against that social group, take the insults, take the he ain't this and whatever, and keep on trucking, because at least that way they know when that attorney comes into the courtroom, they don't have a friend. Prosecutor knows he don't have a friend. He don't have a friend. You have an attorney that will stand up and squawk, and that will have an impact, at least to try to keep the system somewhat honest.
Allie, did you have
yes, but more in general, like generally related to being wrongfully convicted. At some point, we're gonna have to talk about these jurors, these juries. Is it supposed to be your peer? Like it's, and we know it's not your peers ever, from what I've seen. That's a big piece of it too. And just think about these high-profile cases and the juries that were involved. It just, even those alone, it wasn't fair. Yeah, that process just, it just needs to be redone, because a Black man having an all-white jury, and you don't know what biases they have, like you don't.
Right.
It's scary.
Right. Sherry People said she agrees with you, Edward. She said, yes, Campbell, Culpepper, Cornelius Pitts. When your freedom's at risk, sad but true. You go with who they say can get you out. So you go for these names because.
No, and I'm not gonna point out which one of those names, but one of the names that she got up there, like all those attorneys that are mentioned there, I had great admiration for. One of these particular attorneys, I was a jailhouse attorney. You know, I'm not an attorney, but I played one while I was in prison. All right. So, and I often took and had to read guys' transcripts and give them my opinion in regards to their case. There was one guy that had a 650 case. You know, he had got caught with he had two cases because he was out on bond and still got caught with another more than 650 grams of cocaine. So he was facing not one life in prison, but 2 lives in prison, which he he ultimately got, because he had access to that stuff and he didn't know how to stay away from it to take and make money. But in any case, he was paying me to look at his case and to give him my advice. And I looked at it and I told him, there's no errors in your case, with the exception of your attorney. And I said, your attorney bullied the prosecutor because the prosecutor was a woman. And I said the jury had to take him frown on this damn fool. He came in the courtroom and showed so much arrogance every time that the prosecutor tried to present her case or do anything. He spent his time belittling it. And I was like, this guy, where do you think he living? Back in the 50s some damn where? This ain't the 50s any damn more. And that's what he did. He literally spent his whole time. That was his defense. He had no defense. So he just literally took and tried to pull this woman down that was prosecuting the case. And I told him that he had to harm you. That's the only argument that I can see you can go back to court and argue, is that your damn attorney was so arrogant and so chauvinist that it affected your defense.
Beulah said I guess when we was talking about, when Ali was talking about the trial jury, that's a Wayne County issue. The jurors, ever since Malice Green, those people have changed that law. That's one of the reasons, and I agree with Beulah and Ali. I had my first rally in Redford, and when I went to set up the rally in Redford, somehow got my phone number and called me. They said, why are you having a rally in Redford? Well, it didn't happen here. And because most of the people who come to the jury to sit on the juries is from Redford and Livonia and Dearborn and places like that. And when you're in Detroit, you're just preaching to the choir. We all know. But we have to take these conversations to these areas where they don't look like us, but they go to jury duty. Because when they come to jury duty, and I have to agree with you guys, one of you guys said earlier, they have biases. So they look at you and they watch, CSI and all those things, and they listen to the news at night, and they come in and look at you, and they already say, hey, you look like some guy I saw last week on CSI, or this is a familiar story. So they bring these biases because our people make 51 excuses why they can't sit on the trial. They can't, I had this problem, or I don't, it happened to me. They make excuses and they leave, and this is what you left with. So we have to, not only talk to our own people, but we also gonna have to educate those that come to jury duty so they can look a different way. They don't hear these stories. These are not the topics of their conversation. That's why we're doing it on Fridays at 6:00, so we can kind of get this information out, because we're already at a disadvantage when you start the whole process of the criminal with the criminal justice system.
It's like, I was just gonna say, speaking to how people don't know, we are educating people. Speaking to that, there's still people trying to understand. We may have had all that happened in 2020 with Trump and how he was just vocal about racism, with what happened to Breonna Taylor, George Floyd, and so many more. Unfortunately, we have had that. A lot of people have waken up, but there are people who have not. I literally attended an event with Michigan Liberation. It was a coalition building type of event. And it was some organizers there from Farmington Hills. And they were it was people there saying that the only way they know about Black people is from watching TV. They have no Black friends. They have not had that exposure. So there's people still out here like that.
Yeah.
And even if they're on the left, they're still like that. Being on the left does not make you, someone who can identify these problems. You can still very well be racist and be on the left. So we still have a lot of work to do.
Right. And we have to start doing something different. We've been doing the same thing, expecting a different result. And that's called insanity. We had to do something different. And if that means we got to go in Livonia, we got to go in these communities that don't look like us but show up, we got to educate. We have to do more to educate. Not only do we have to educate our people, but we have to educate them as well. It's our job.
It's you know, it's also people have to call out racism too, though. Like our people, we do stuff, but we also need allies to call it out and to speak to people, because they see each other, like they probably see each other more than I see them, of course. So they need to do that. You know, it's enough room for everybody to fight this fight.
Right.
We can't be doing everything.
Right. Go ahead, Edward.
And I appreciate Allie bringing up the issue relevant to jury. We have jury instructions that literally are instruments of Jim Crow laws and practices, and we don't have these African American attorneys calling it out. We don't have these African American judges calling them out and saying that I won't allow that instruction in my courtroom. It's based on the exclusion of African American people. And we haven't had this. And you can't tell me that in a predominantly African American city that you don't have the comfort zone to say that. You know, the courtroom that Kim Worthy took and gained her name and reputation in, that judge threw out a case where police had been shot and allegedly someone ran into the church. Okay, and the police came in because no one in the church took and identified who the person is supposed to be. So they took the whole church to prison, to the county jail, and that judge released every single one of them. That was an African American judge, and that happened in a time when there was very few African American judges on the bench. And you now tell me that you're the prosecutor of the state of Michigan, you're the most predominant prosecutor, that you hold yourself up at the same damn level as the attorney general or the county executive, and you can't speak justice, you can't speak truth. You know, these type of things have to stop. We have to quit giving each other excuse because of our black skin.
Right.
That's not a damn excuse. In the case of Peoples versus Aaron, where we had the felony murder rule, that felony murder rule goes back to Jim Crowism. It took and said that if you are accused of a crime and someone got killed, even though you didn't intend the murder, the fact that you was doing something wrong, you responsible for the capital offense of murder, which they predominantly use laws like that against African Americans. So we still have people here in the state of Michigan that are still in prison for crimes like that. Okay, when they took and said that it was wrong that Michigan now have a statutory law and that they shouldn't have been using this common law, they nevertheless didn't make it retroactive. It was like, oh, we already got you guys. Okay, we got 100 or more you guys in prison under this felony murder rule, not the felony murder statute, but a felony murder rule that goes back into not only to English law, which the court took and swept under the rug by simply blaming it on English law. It didn't just include English law, it includes Jim Crowism, just like the practice of taking and saying that you can have a jury and they can be split. The 12 members of the jury can be split. You can have 6 to say it was premeditated murder, first degree, and you can have another 6 to say it was felony, and they don't care. They say that's a unanimous verdict. Put him in jail. For who? It only applies to us as a people. And African Americans, they may have argued just the technicality of the right, but they haven't brought out this racist history of these laws. Yeah. You know, and we need to take and call that out. We need to call that out.
Right. Attorney Hugo Mack, do you want to say something?
No, you know, I mean, it's a daunting task. I mean, I'm not telling anybody here anything you don't know. Yeah. You know, but the thing of it is not to give up. You know, And one thing we have to do is we need to constantly redefine success. You see, we have to get to a point of defining what success is. We can no longer allow other people to define success. If a person is wrongfully convicted and that conviction is never reversed, some would say that you failed. You did not have success because that conviction was not reversed. That's not true. How you react to that wrongful conviction, or even if you're rightfully convicted and spent excess amount of time in the penitentiary, how you react to that, that's got to be your measure of success. If you keep your humanity, you keep your sanity, you keep your dignity, you keep the God force in you, and can come out and not only help people that when you get out, but help people when you're in there. See, that is what your definition of success needs to be. And that's what I preach all the time to people, clients that I have, to come out and say, Mr. Mack, I'm a loser. I said, don't you dare accept that. Don't you dare accept that. You here above ground breathing, brother or sister. So you automatically be given a chance by God for success, So let's just keep redefining success to what our heart and our soul is leading us, not by what society says about us.
Right. Tia?
Wait, I was up here saying yes, yes, and yes. I like that because, we have to, and I agree with Attorney Hugo Mack that we must redefine success, because I said earlier today, people are going to see what they see. And it's up to us to really realize, what are we looking at? What is the real perception that we have about ourselves and about others? Because we are constantly seeing what we see. We will constantly continue to see our past if we don't change what we're looking at.
Mm-hmm.
And so we have to redefine success individually and collectively, because it's no longer, success does not mean how many cases you win.
Right.
That's not success.
Right. That's right.
But how many people did you advocate for? Where's your right mind and right action? Right mind and right action has to line up. And as citizens, we've got to redefine success so that we only want things that are going to build our character. And it doesn't mean that we're going to be poor in doing it. But when we redefine success, we also redefine the avenues of prosperity. Mm-hmm. And that's in many different ways. So I thank you, Janice. Thank you so much for allowing this panel to continue. I'm excited about the change that is coming and is right now.
Yes, me too.
Change is on the menu and it's happening regardless.
That's right.
Attitude.
That's right.
So we're over our time again, as usual, but it's cool. We started off a little late. But I thank you guys. This was a conversation that we can have and continue to have, because we need to educate ourselves and educate our community, our family members, because it is important to know your rights, to know, what to look for if you get into a situation, and to have some knowledge that you can, stand up with, because, going in blind, you don't know anything, you'll go for anything. So I thank you guys. I'm going to go around to each one of you. I'm going to start with Allie. What is it that you would like to leave everyone with?
First, I want to say, everyone, please click that link I dropped in the chat to contact your senator by phone, email. Through that link, it'll quickly populate a message where you can easily submit that or edit and express that the Justice and Policing Bill needs to pass. It will end qualified immunity, ban chokeholds, no-knock warrants. as well as require data gathering of police and prosecutors. Do that as soon as possible. We have to make sure the Senate knows that this is important. Also, Accountability for Dearborn has a data town hall coming up on the 20th of this month. This the last one in our series. This one will focus on arrests. We'll be partnering with Carceral State Project, as well as the Justice for Girard movement. And also, we'll be partnering with Michigan Liberation, and more is to come on that.
All right. Thank you, Allie. Edward, what would you like to leave us with?
In addition to taking in addressing the issue of immunity as it relates to police, which is nobody would tell an accused that these are the charges we are considering against you. You got 48 hours to consider them before we get back with you, and then you can give us a response to them. That's what they do with the police. It's ridiculous. And these are professional witnesses. So, yes, we need to take it and bring in this so-called immunity. And I don't understand how a judicial system can be, or the police department can be bound to a labor agreement. This is a labor agreement. You a public servant, and the state has a greater right over your taking and disclosing immediately what you know about the circumstances of the case. Not after you done had 48 hours or 3 days or whatever to consult with an attorney and everybody else about the issue. We give less rights like that to the accused. And for those who are being accused of crime, practice your damn Miranda right. Practice your right to remain silent. Too many of us are willing to talk to the police and then won't talk to your damn attorney. If you got something you want to say, wait until you get an attorney and talk to the attorney. Learn to shut up. They are not going to take and let you go because you got a good story. They want to hear that story. They will use it against you. Not maybe. They will use it against you. Learn to shut up when you're accused of a crime. Ask for an attorney, and beyond that point, shut up.
That's right. You have the right to remain silent. Use it. Reverend Tia.
Boy, I tell you, yes, yes, and yes. I'm so excited about what is happening and the change that is going on. And Allie, we are behind you 100%. I'm going to also share that link. And I'm encouraging everyone to continue to share and spread the activities that are going on within this panel and all the people who are represented here today. I'm just going to give you a quick update on Flint. The judge here, Levy in Ann Arbor, has been the one over the Flint crisis. And they've only decided that each person, each household represented should only get $1,000 for compensation. And the children have to be prove that they've, through some type of bone density examination, that they've had effect from the water. So continue to pray for Flint, and whatever right now, the way that it's going, I didn't even know somebody here in Ann Arbor could judge for something in Flint. And that's what's happening. So I thank everybody here today, and we are going to continue our efforts in all that we do, and change is definitely right now.
Right. So also Tia, as you talk about Flint, I was been watching how is it Evanston, Illinois, where they're gonna approve reparations.
Yes.
So that's Flint needs some reparations.
And they were actually kind of copying, I thought, off of them, and they're trying. I know I've talked to the commissioner who's been kind of leading that way out there, trying to duplicate some of those measures.
Yeah.
Mm-hmm.
What are you saying, Edward? ERA in the news.
I was just letting you all know that there's some released news recently about the ERA. They claiming that some states didn't ratify it on time. So after the show, you guys might want to go take a look at that.
Okay.
Okay.
And last but not least, Attorney Hugo Matt, what you gonna leave us with?
Well, I want to say this. You know, back in 1955, when the Montgomery bus boycott started, people were tired of being sick and tired, okay? And they had a collective effort to make change. And unfortunately, you know, when people come to America and become Americanized, sometimes we have a false sense of security. And what I'm saying is, I run into resistance, and it's disheartening amongst Black people who simply don't want to get involved. Don't want to get involved. I don't have time to sit on no jury. Don't ask me to sit on no jury. I got things I want to do. You know, don't ask me to come to no meeting about the police. You know, I'm doing my own thing, what have you. And it's so hard getting people to become engaged, but it's hard, but it's not impossible. You know, Dr. King, the civil rights movement didn't have all the telecommunications we have right now. They didn't have any of that. You know what I'm saying? The advanced telephone system. But they had a will, and they were tired of being sick and tired. And so that's what I'm encouraging everybody. Keep on pitching the word. We have to get involved. I remember Al Sharpton said about 15 or so years ago when I saw him in Detroit, he said he's always amazed he got to get out here and beg some Black people to vote. Got to beg them to vote, you know, and stuff. And I said, that's right, Reverend, you know. So we have had a hell of a mojo put on us. I mean, I got to be honest. When we take up the mantle of the oppressor, all right, and fight for the oppressor, like Malcolm said, the house Negro, he would love the master more than the master loved himself. You know, the house, when the master's house caught on fire, he'd be the first one to run up in there with a bucket of water. You see what I'm saying? So you know, we just have to overcome that culture within ourselves, and you know, I think I lived in the field. I don't think I'd been in the house. I mean, it's easy for me to say that now, but if I was in the house, I'd wanted to been in the field. You know, so I believe. So anyway, so keep up the fight, keep up the struggle. Don't be discouraged, because we win if we don't stop.
Yes. So I want to leave everyone with, I posted this up because I want you to know that in the United States, they spend less on public defense than they do in other countries. So the deck is stacked against us from the beginning. Understand that, and understand that it is our duty to fight. Mm-hmm. We have to, you know, not only vote, but we have to stand up and we have to support each other. And when someone is telling you something, listen and don't judge. Do your due diligence. We have Google, like Attorney Hugo Matt said, you know, during the civil rights era, they didn't have all the things that we have, but we have our platforms that we, Facebook and so all kinds of social media platforms. We have Google. We have so many things in our hands every day. We walk around with a whole thing of knowledge, and we use it almost every day. Use that. Speak truth to power. Don't be afraid. Sam says all the time, when we organize, we win. So I want to thank everyone for joining us, and I love you guys. And we'll see you next week on Turning a Moment into a Movement.
If I can inject something just before we leave off. One thing.
Go ahead.
I'm very disappointed in our vice president, she could have allowed the president to do that if the United States wanted to do this. She got on a telephone call with the Prime Minister of Israel to notify him that the United States would object to inquiry Israel taking in civil human rights violations of Palestinians in the occupied territories. I think that for African Americans to take an object to someone that is under oppressor like the Palestinians are, I think it's outrageous. We should never take an object to anybody. That's like somebody standing up and saying they would object to inquiry of the United Nations for South Africa apartheid. It's wrong. We should take and speak up. You know, it's wrong, and those are the kind of fears that I had about her because of her history. And I'm gonna speak up and speak up early. I know some of us want to be proud that there's a Black woman in that position. But it's wrong. We should speak up for Palestinians or whoever. If you want to quote Dr. King, quote him now. Thank you.
Absolutely. I agree. I had my issues with her, but you know, I agree. So I'm going to leave us with this. It is our duty to fight for our freedoms. It is our duty to win. We must love, respect, and support each other. We have nothing to lose but our change. See you guys next Friday, turning a moment into a movement.
God bless and thank you.
Yes, thank you.